Madam Clerk of Court, please call the cases before us.
Good afternoon, Your Honors. This is a continuation of the oral arguments on the consolidated petitions in GR number 274778, Aquilino Pimentel III et al., petitioners, versus House of Representatives, represented by the Speaker, Ferdinand Martin Romualdez et al., respondents, GR number 275405, Bayan Muna Chairperson Nery Colmenares et al., petitioners, versus Executive Secretary Lucas P. Bersamin et al., respondents, and GR number 276233, One Sambayan Coalition et al., petitioners, versus the House of Representatives, represented by the Speaker, Ferdinand Martin Romualdez et al., respondents. Thank you, Your Honor.
Appearances, please.
Good afternoon, Your Honors. Respectfully appearing for petitioners Pimentel et al., Paula Maytankeng, Your Honor. Together with me is Michael Ocampo.
Nery Colmenares, Your Honor, for petitioner Bayan Muna Party List et al.
Attorney Maria Cristina Yambot, good afternoon, Your Honors. For the petitioners Bayan Muna et al.
Good afternoon, Your Honors. Attorney Howard Calleja for Isang Bayan Coalition, members of UP Class 95, and Father Flavi, Your Honor.
Good afternoon, Your Honors. Attorney Joseph Peter Calleja, respectfully appearing for Senior for Seniors Association Incorporated, Kidney Foundation of the Philippines, and the San Beda Alabang Human Rights Group.
Hello. Good afternoon, Your Honors. Attorney Christopher Lau, respectfully appearing as counsel for petitioners Sambayan et al.
Good afternoon, Your Honors. Sani Matula, representing the petitioners in intervention trade union leaders of Nagkaisa Labor Coalition, Federation of Free Workers et al. Thank you.
Good afternoon, Your Honors. Good afternoon, distinguished amici and everyone in the session hall. I am respectfully re-entering the appearance of the Office of the Solicitor General for all the public respondents except Philhealth. Together with me this afternoon are ASG George Ortha II, ASG Maria Victoria Sardillo, and State Solicitor Rowena Mucha, and scores of OSG lawyers in the gallery. We're ready for interpellation, Your Honor.
Good afternoon, Your Honors. Solomon Hermosura and Melissa Acorda of the Office of the Government Corporate Counsel, respectfully appearing for respondent Philhealth. We have in the gallery lawyers from our office who will also provide support. If I may mention, Your Honors, we have earlier filed a manifestation asking the court to excuse the attendance of Secretaries Pangandaman, Laguesma, and Gatchalian as ex officio board members of Philhealth because of conflict in their schedule, Your Honors. But they are represented here by the alternate directors, Your Honors.
The manifestation is duly noted. We recognize the presence of Ralph Recto, Secretary of Finance, Secretary Teddy Herbosa of the Secretary of Health, Philhealth President Edwin Mercado, and the Amici, former Secretary of Finance Margarito Tebes, Orbil Jose Solon, Zaiza Nadine M. Zuzara, Mr. Sani Africa around, and Beverly Lorraine Ho. We also acknowledge the presence of our former colleague, Senior Associate Justice Antonio Carpio, and Associate Justice Conchita Carpio Morales, petitioners. Thank you. Justice Ami lazaro-javier will resume her interpellation.
Thank you, Chief Justice. May I recall Government Corporate Counsel, Attorney Solomon Hermosura, for interpellation.
Good afternoon, Your Honors.
Yes, good afternoon, Mr. Government Corporate Counsel, Attorney Hermosura. May I request Attorney Cuevas to please read into the records the pertinent TSN of the proceedings during the first day of the oral argument on February 4, 2025, pages 68 to 69.
With the kind indulgence of the court, and I quote, Associate Justice Lazaro-Javier, yes, so I would like to go back to my question earlier. When do you decide to just assign a portion or the full 30 billion to cover the reserve funds? Yes, Attorney Hermosura. Attorney Hermosura, I can answer based on the Universal Health Care Act, Your Honor. Associate Justice Lazaro-Javier, yes. Attorney Hermosura, I have read the law and the law does not prescribe the factors that the Philhealth Board should consider. So that's why, in my view, it is addressed to the business judgment. And I have been in the boards of many companies and I have seen the various ways business judgment can be exercised. Some people can be conservative, some people can be aggressive. I would say that I will not, let's say, if I were in the Philhealth Board, I will not set a high reserve fund if I am confident that I can get political support for a bigger subsidy for Philhealth. Because there is no limit to the subsidy that government can provide to Philhealth, Your Honor. And if I may also mention, the liabilities of Philhealth are guaranteed by the Republic of the Philippines. Associate Justice Lazaro-Javier, all right. So you mean to say that the subsidy of government can come anytime depending on the needs of Philhealth? Yes. Yes, Attorney Hermosura, it is settled, Your Honor, that a social health insurance is a matter of political negotiation. Associate Justice Lazaro-Javier, well, I do not know about that. I just want to simplify things, unquote. Thank you, Your Honor.
Thank you, Attorney Cuevas. So these are my questions. Attorney Hermosura, what do you mean by political negotiation?
Your Honor, if I may just also explain that I was responding to your last question, meaning as read by the clerk of court, the question of, you mean to say that the subsidy of government can come anytime depending on the needs of Philhealth? Yes, yeah. So if I had the opportunity, Your Honors, I would have elaborated that Section 37 of the Universal Health Care Act provides, and I quote from the law, Your Honor, the DOH, in coordination with Philhealth, may request Congress to appropriate supplemental funding to meet targeted milestones of this act. I would have also mentioned, Your Honors, that the government has done more to advance universal health care during this administration than in past administration.
Yes, noted. So, yes, would you like to continue?
I think what I mean, Your Honor, by so if there is a need for more funds, Your Honor, for Philhealth, they can ask the Congress for supplemental funding that is under the Universal Health Care Act. And anytime that the Congress and the executive allot resources for government projects, Your Honors, that is a political process. It's a decision on resource allocation and prioritization of societal needs, which are the outcomes of negotiation among the government, civil society, and other stakeholders.
Political negotiations. Is 37 negotiable? Yes. Section 37, is that negotiable? UHCA, the sources of appropriations for Philhealth?
You're referring to Section 37 of the National Health Insurance
Yes, the sources of appropriations. Is that negotiable?
Well, in the sense that if those sources are not enough, Your Honor, the DOH, together with PhilHealth, can ask for supplemental funding from Congress. Your
Yes,
Honor.
but we're not even talking about the supplemental budget. Very clearly, I understand from your statement that the fixing of the amount of the reserve fund would depend on your confidence whether you will get much political support or not. Meaning, and you said that if you were confident to get support, political support, political support, you would not fix a high reserve fund. What does that mean? The amount of reserve fund would depend on your
No,
on your expectation.
no, I was responding to your immediate question, Your Honor, which was whether I meant to say that the subsidy of government can come anytime, depending on the needs of PhilHealth.
Yes.
And so, I mean, when PhilHealth so needs, then the DOH, together with PhilHealth, can request for supplemental budget, Your Honors.
Yes.
That's all that I meant, Your Honor.
That's all that you meant. All right, but of course we cannot segregate or separate that from your earlier statement that you have read the law and the law does not prescribe the factors that the PhilHealth Board should consider. So that's why, in my view, it is addressed to the business judgment. We're talking here of business judgment. And I have been in the boards of many companies, and I have seen the various ways business judgment can be exercised. Some people can be conservative. Some people can be aggressive. I would say that I will not, let's say, if I were in the PhilHealth Board, I will not set a high reserve fund if I am confident that I can get political support for a bigger subsidy for PhilHealth, because there is no limit to the subsidy that government can provide to PhilHealth, Your Honor. And if I may also mention, the liabilities of PhilHealth are guaranteed by the Republic of the Philippines. This just gives me the impression that from your statement that the reserve fund, the amount that the board may fix, would depend on something that may or may not come, like the subsidy of the government. You have first to negotiate. And even after you have negotiated, there is no certainty at all that the subsidy you would like to receive will be given by the government. That is my impression from your statement.
Well, actually, I was referring to many variables that may be considered by the PhilHealth Board, Your Honor. Actually, if you so require me, Your Honor, I can share materials, including a report of the World Health Organization in 2010 on health system financing, which discusses how moving toward a universal health care is fundamentally a political process.
Yes, that leads me to my next question. Your statement was, it is settled that social health insurance is a matter of political negotiation. You know, honestly, this is the first time I've heard of this. I've always believed that health is non-negotiable. And can you please respond if it is settled in jurisprudence or law that health insurance is a matter of political negotiation?
I'm referring to these materials from a World Health Organization report in 2010. I can share the materials.
You are saying that it is settled. Settled by who? Where?
Oh, it's like a general understanding. That's what I mean, Your Honor.
All right, so there is no jurisprudence, there is no law.
No, Your Honors, but
Yes.
One administration can do better than others. And I can say that this administration has done better than the past. I think I look at the numbers, and just for 6 years, from 2016 to 2022, Philhealth's corporate operating budget increased by 25%, from 126.4 billion to 168 billion.
All right, that's well
While-
taken.
For 3 years of this administration, from 2022 to 2025, Philhealth's corporate operating budget increased by 41%, from 168 billion to
All right,
284 billion.
noted. And I would appreciate, the court would appreciate if you will include that as one of your submissions to the court.
Yes,
All
Your
right.
Honors.
So, when you speak of government subsidy, do you refer to the funds coming from PAGCOR, Syntax, PCSO, DOH appropriations, or government subsidy that is altogether separate and distinct from
Well-
these sources?
Actually, the Section 37, Section 37 of the Universal Health Insurance Act, Your Honor, says that all the amount necessary to implement this universal health insurance shall be sourced from
Yes.
those
So
that you...
my question I would like to repeat is, when you speak of government subsidy, do you speak of the funds coming from PAGCOR, from Syntax, from PCSO, DOH appropriations, or government subsidy that is independent from these sources altogether?
Actually, all those sources of funds, Your Honor, they are implemented through the provisions also under Section 37. It
Yes.
says, the last paragraph, Your Honor, it says, the amount necessary to implement the provisions of this act shall be included in the General Appropriations Act
Correct.
and shall be appropriated under the DOH and the national government subsidy to Philhealth.
Correct. So, is it safe to say that this is an automatic appropriation every single year? Because the funds need not be fixed anymore by the Congress, because the amounts are already fixed by law.
Well, my understanding of the
So
section...
is it the subject of automatic appropriation every year?
The law doesn't mention automatic appropriation, Your Honor.
Can you please read the provision?
Well,
Yes.
the first part says, Your Honor, the amount necessary to implement this act shall be sourced from the following. And then it's
Yes.
an enumeration of the sources, Your Honors.
All right. And the first one is the total incremental Syntax collections. And in relation to 10351, it says that after deducting the allocations under Republic Act 7171 and 8240, 80% of the remaining balance of the incremental revenue derived shall be allocated for the universal health care under the National Health Insurance Program, the attainment of the Millennium Development Goals, and Health Awareness Program. Is that not automatic?
From the PhilHealth's perspective, Your Honor, it receives the appropriations for premium contributions of...
I'm not even
yes.
speaking about premium contributions. I'm just speaking about the sources coming from Syntaxes, from PCSO, from PAGCOR.
Because the last paragraph of this provision, Your Honors, also specifies the mode of operationalizing this provision. And it says...
How?
It says the amount necessary to implement the provisions of this act shall be included in the GAA.
Of course, it should be
Yes.
indicated in the GAA because by then, the amounts would have been certain already. All right. So, at any rate, from your statement last time, I gathered that the higher the amount of subsidy you expect from the government through the so-called political negotiation, the lesser the amount of reserve funds you will earmark coming from the accumulated assets of Philhealth. Is that correct?
The higher the
Yes.
No,
the higher you expect from the
The-
government through the so-called political negotiation, the lesser the amount of reserve funds you will earmark coming from the accumulated assets of Philhealth.
I'm
Is that correct?
I don't remember that, Your Honor, but I know that the practice of Philhealth, Your Honor, has been to set the reserve fund equal to or lower than
Yes,
the ceiling.
but you forgot about your statement already. We just read it back, and I don't wish to read it back again. Anyway, from your statement as well, the amount of reserve funds, it would seem to me, does not depend on the amount of PhilHealth's accumulated revenues, but on the amount it expects to receive from the government, which is a mere expectation that may or may not become real.
I'm sorry, Your Honor, I can't. I can't remember saying.
All right, it's okay. And I just would like to stress that under Section 11 of the Universal Health Care Act, the reserve funds must be sourced from the accumulated revenues of the agency. And when you say accumulated revenues, it means that they already include the taxes or the subsidy from the government and all the monies collected coming from the sources enumerated under Section 37.
That is correct, Your Honor.
Yes. So with that, Attorney Hermosura, I really thank you very much, and you are excused.
Thank you, Your Honor.
Thank you. May I continue, Chief Justice? May I now call on Senior Vice President Lim Siaco of Philhealth to respond to my next questions.
Good afternoon, Your Honors.
Yes, good afternoon, Senior Vice President Lim Siaco.
Good afternoon, ma'am.
Yes. So, would you agree that political negotiation is a principal factor in determining the amount of reserve funds to be fixed by the PhilHealth Board?
Your Honor, in the coming up of the approved JAA for Philhealth, PhilHealth submitted the proposal, and based on the evaluation of DBM, it will be incorporated in the NEP,
Yes.
Your Honor. And during the time that it will be deliberated in the Congress, Your Honor, that's the time that on the part of, as mentioned by GCC, Your Honor, political negotiations come in. It is either retained based on the NEP or it will be increased, Your Honor, depending on the appreciation of the Congress as well, Your Honor.
All right. So does it mean that you still negotiate the transmittal of the appropriations fixed by law under Section 37?
Your Honor, we have Section 37, Your Honor, but of course, in the final JA, Your Honor, it is negotiation, Your Honor, Philhealth, Department of Health, and the Congress, Your Honor, on
You have
what
to negotiate
particular-
it, notwithstanding the clear command of Section 37 that the appropriations shall come from these funds, from these sources. You have to negotiate.
Your Honor, negotiation in the sense that, of course, the Congress asking PhilHealth on its utilization of the previous and the implementation of the program as well, Your Honor. And it is our on the side of PhilHealth, Your Honor, we depend the proposal of the corporation, Your Honor, of course, and that it will be retained based on the NEP or it will be increased, Your Honor.
So the percentages are negotiated even though they are fixed by law, like 50% from PCSO.
Your Honor,
80% from syntax. Do you still negotiate or it should be automatic?
Your Honor, depending on the amount that will be computed by Department of Finance, Your Honor, on the percentages.
You know, the amount is a mere arithmetical computation. We go by the percentages fixed by law.
Yes, Your Honor.
So despite the percentages fixed by law, you know, the actual amount, it's just a computation. So does it mean that Congress is not following the percentages prescribed by law?
Your Honor, in the past years, Your Honor, based on the NEP, it is carried, Your Honor, in the General Appropriations Act.
You know, my question is very clear.
Yes, po.
I'm talking about the percentages fixed by law under Section 37. My impression from your statement is that despite the percentages already fixed by law, the Congress, you still need to negotiate with Congress for the actual percentages that may be included in the GAA for the subsidy of PhilHealth. Is that the reality on the ground?
Yes, Your Honor. We tried to defend the proposal of the corporation,
All
Your
right.
Honor.
Yes, well taken. So now I proceed from where we left off last Tuesday. I would like to finish with the COA's basis for disclaimer of opinion issued in 2022. Attorney Cuevas, can you help us again? Read into the records.
The faithful representation of the provision for health benefits incurred but not reported account with year-end balance of 95.099 billion pesos is doubtful due to significant risks of misstatement resulting from unexpended balances of accrued liabilities between 2018 and 2021, ranging from 8.808 billion pesos to 37.722 billion pesos, which runs counter to the required fair and faithful presentation of financial transactions as outlined in the Philippine Accounting Standards and the Conceptual Framework for Financial Reporting. May I continue, Your Honor?
Yes, please continue.
In addition, there are other issues that further compromise the accuracy of the account, which include letter A, the absence of a well-defined policy on the proper accounting of prior years in course of settlement or ICS claims, resulted in the failure to assess the reasonableness of the unexpected balance of ICS from prior years, amounting to 17.161 billion pesos. And letter B, presence of irregularities in the calendar year 2022 admissions, including 1, 6,798 claims amounting to 63.985 million pesos from 3,380 unique Philhealth identification numbers or PINs, but different member names. 2, 710 claims amounting to 6.388 million pesos from 355 members with 2 different PINs. And 3, 1,583 claims amounting to 4.632 million pesos with irregular or incomplete entries/data due to the absence of system controls. These issues increase the risk of misstatement of the account, hence cannot be considered to have represented fairly the subject transactions as required under the Philippine accounting standards.
Continue.
The reliability of the financial liabilities account with a year-end balance of 3.349 billion pesos is doubtful due to the presence of 94,625 claims amounting to 1.450 billion pesos that were returned to healthcare institutions or HCIs beyond the 60-day turnaround time prescribed by the National Health Insurance Act. In addition, 664 claims amounting to 3.649 million pesos were found to have irregular entries or data which do not accurately represent the actual transactions required under the Philippine accounting standards. The absence of a well-defined policy and sufficient controls to regulate these transactions poses a significant risk of unreliable balances, unsettled liabilities, and decreased operational efficiency in the processing and payment of claims.
Thank
Your Honor.
you. Thank you. Okay. Mr. Senior Vice President, according to you, during the last oral argument at a certain cut-off period, Philhealth has settled all its obligations, hence is left with no unpaid obligations for that certain cut-off period. Is that correct?
Your Honor, I cannot recall that saying that one, Your Honor. But my statement, Your Honor, if I may, Your Honor, in any certain given cutoff date, Philhealth still have a payable to the hospital, meaning claims will be processed, but claims will also enter the Philhealth system for processing, Your Honor.
So those that enter the system of Philhealth are the approved claims?
Not yet,
Yes,
Your Honor.
not yet.
Because it will be submitted to Philhealth, received by Philhealth, and will be processed by Philhealth, Your Honor.
All right. Now, how reliable are the numbers, or were the numbers you reported in your financial report?
Your Honor, when we talk about reliability, Your Honor, we are trying to come up with a fair
Yes.
presentation of the FS, Your Honor.
Yes, but
and we
your-
received 15 million claims, if may, Your Honor, 15 million claims per year, Your Honor. And of course, on the 15 million claims, Your Honor, makikita ho natin that there are some claims that has found out by COA that has some needs to be rectified, Your Honor.
Yes, so you do not challenge the finding of COA that Philhealth lacked sufficient controls to keep track of its transactions.
Your
Yes,
Honor, we are,
thus increasing the risk for unsettled liabilities.
Your Honor, we are addressing the findings of COA, Your Honor, to put controls and change the process of recording, Your Honor. And Your Honor, we have this program right now, the FinMare program, Your Honor, that proper way of recording of our benefit claims, Your Honor, in our books of accounts, Your Honor.
So this observation of COA is accurate.
Your Honor, we confirm, Your Honor, that findings of the Commission on Audit, Your Honor.
So because of this, the numbers indicated in your financial statements cannot be completely relied upon.
Your Honor, the reliability, Your Honor, depending on the materiality of the findings, Your Honor. So again, as I mentioned, Your Honor, we have 15 million claims in a year, amounting to nearly 150 billion pesos, Your Honor.
So it means that PhilHealth is not capable of processing all the claims that are filed with it in a given year.
Your Honor, you're correct, Your Honor, because as I mentioned, Your Honor, claims come into the PhilHealth for processing and claims will be paid. But as of certain given times, say for instance, December 31, Your Honor, there are still claims unprocessed or unprocessed, Your Honor, given that PhilHealth has given 60 days to process a claim, Your Honor.
You cannot cope up with 15 million claims
Your Honor,
yearly.
Your Honor, if saying to zero out the claims as of a given date, Your Honor, it is impossible, Your Honor, given again in any given period, Your Honor, claims pumapasok sa sistema ng PhilHealth for processing,
But
Your
all
Honor.
these claims are coming from people who are sick, who need urgent financial assistance to settle their hospital bills. These people, many of them are fighting for their lives in the hospitals. Perhaps all 15 million claims filed with your office.
Your
Yes.
Honor, the claims is being filed by the health facilities, Your Honor. In other words, the hospital received the document from the patient and the hospital or the health facilities be the one to submit the claims to PhilHealth, Your Honor. Again, I would like to mention, Your Honor, that PhilHealth has given 60 days to process the claims, Your
Yes,
Honor.
and according also to the findings of COA, the 60-day run-around period has not been complied with.
Your Honor, there are instances, Your Honor, that claims filed, paid beyond 60 days, Your Honor. But, Your Honor, I would like to state, Your Honor, that majority of the claims, majority or I have the figures, Your Honor.
Yes, we'll see
I just
about
want to see that one.
Now, let us go to your 2023 financial statement.
Yes, po.
You know, it's very important that we become aware of your financial standing, your status for these 3 years, 21, 22, 23, because it is from these years that the 89 billion was charged, was collected, and transferred to the National Treasury, 69.9. Had not the last tranche been restrained. All right. So we flash on the screen the 2023 financial statement of PhilHealth. In 2023, the COA reported that the total assets of PhilHealth amounted to 588 billion plus. The total liabilities amounted to 1.2 trillion plus. Out of 1.2 trillion plus, 1.14 trillion plus represented Philhealth's insurance contract liabilities. Based on these numbers coming from COA, Philhealth had a negative equity of 663 billion plus in 2023. Per independent auditor's report dated September 11, 2024, or just 6 months ago, the COA issued a qualified opinion, which means that this time, at least partially, Philhealth's financial statements present fairly in all material aspects the financial position of Philhealth as of December 31, 2023, and its financial performance. But for the rest of the financial statements, COA issued a qualified opinion. So may I again request Attorney Cuevas, please don't get tired, Attorney Cuevas, to read the pertinent portions of COA's independent auditor's report.
I quote, "The faithful representation in the financial statements for insurance contract liabilities or ICL amounting to 1.150 trillion pesos and 266.873 billion pesos for calendar years 2023 and 2022 respectively cannot be ascertained due to the following factors. Letter A, the completeness and accuracy of the claims and premium data cannot be established, casting doubt on the reliability of the reported figures. Letter B, the evaluation of the calendar year 2023 actuarial valuation report intended to assess the adequacy of the ICL revealed inconsistencies and irregularities that affects its reliability and validity to third parties. Letter C, the use of different measurement basis for the provision for ICL diminishes the comparability of information in the financial statements, hindering the users from making informed economic decisions. And letter D, the absence of reasonableness test on expense loading further undermines the reliability of the ICL account in the financial statements, which are inconsistent with Philippine accounting standards, Philippine financial reporting standard, and revised conceptual framework for financial reporting." Unquote.
Thank you, Attorney Cueva. So in fine, again, 1.15 trillion plus ICL for 2023 was misstated, according to COA. And more likely than not, if correctly reported, would have been bigger. So Attorney Cuevas, please continue reading the COA's report.
And I quote, "The presentation and disclosures of provisions and contingencies are not in compliance with the minimum requirements of the Philippine accounting standards due to the following issues. Letter A, provisions and contingent liabilities for appealed benefit claims are not adequately presented or disclosed in the financial statements due to an insufficient monitoring and reporting mechanism, resulting in the misstatement of accrued benefit claims, payable and provision for health benefits incurred but not reported by an unidentified amount. And letter B, contingent assets arising from outstanding legal cases are improperly disclosed in the notes to financial statements due to the lack of policy on specific classification criteria for estimating the outcome of the inflow of economic benefits." Thank you, Your Honor.
Thank you, Attorney Cuevas. I cannot thank you enough. According to COA, there are multiple unreported transactions. Hence, we can say that if all the transactions were reported, the total liabilities of COA would have been significantly greater than the reported figure. In some, COA was saying that the records made available to it pertaining to the reported transactions being incomplete cannot be the basis of an accurate audit of the total liabilities of Philhealth because, again, there are numerous unreported transactions. So for the last time, Attorney Cuevas, may I request you to read the other observations of COA?
In preparing the financial statements, management is responsible for assessing the Philhealth's ability to continue as a going concern, disclosing, as applicable, matters related to going concern and using the going concern basis of accounting unless management either intends to liquidate the Philhealth or to cease operations or has no realistic alternative but to do so. Thank you, Your Honor.
Thank you again. Right. So, Mr. Senior Vice President, yes. Are you also a doctor or a lawyer or an engineer or architect?
Your Honor, I am not a lawyer. I am a certified public accountant and has a doctorate degree in human resource, Your Honor.
Yeah. How long have you been with Philhealth, sir?
Your Honor, this is my 24th years, 23rd years with Philhealth, Your Honor.
So you have the institution, you're the institutional memory of Philhealth. You should be preserved.
Thank you, Your Honor.
Thank
you,
you.
Your Honor.
So, my question is, based on these COA reports, do you think Philhealth still has the ability to continue as a going concern without aid from the national government?
Your Honor, Philhealth is a government-owned and controlled corporation. And Philhealth can continuously implement this program, can operate, Your Honor, even, as you mentioned, Your Honor, without a subsidy from the national government, Your Honor. Of course, the subsidy of the national government is very important, Your Honor, for the expansion of benefits and, of course, the expansion of beneficiaries already given by Republic Act 11223, Your Honor.
Are you telling the court that never has the national government rescued Philhealth?
Your Honor,
when it comes to its inability, supposed inability to meet or pay all its liabilities, the government never came to the rescue of Philhealth?
Your Honor, hindi pa naman ho dumating sa...
Hindi pa dumating sa puntong yon.
Yes,
ano
Your
pala
Honor.
ang narating natin?
Your Honor, Philhealth continuously implement its program. And our board, which kasama po the national government, we have the DBM, we have the Department of Finance, and other government agencies, Your Honor, looking into the operations of the corporation.
So no need to negotiate with the national government on subsidy because you are self-sufficient.
Your Honor, on the self-sufficiency, Your Honor, again, the National Health Insurance Program, Your Honor, will be expanded and the universal health care will be attained once mayroon ho, of course, subsidy from the national government, Your Honor.
So you will still depend. And up to now, you are depending.
Yes, po,
From
Your
the
Honor.
very start, you have been depending on the national government subsidy, right?
Yes, Your Honor.
All right. So without the national government subsidy, would you have collapsed?
Your Honor, if the expansion of benefit that made in the year 2020 for Your Honor, ma-implement natin ng tuloy-tuloy, Your Honor, of course, kailangan natin ng national government subsidy, Your Honor.
So we're looking forward, moving forward.
Yes, Your Honor.
But where you are standing now, your situation now, the present financial status of Philhealth, do you need rescue from the national government?
Your Honor, the the status of the financial of Philhealth right now, Your Honor, enough to cover the year 2025 operations, Your Honor?
Oath.
Yes, Your Honor.
Yes. All right. That opinion,
Your Honor, that is based on the financial record, Your Honor.
even with the findings of COA, you will still insist that you're financially sound,
Yes, Your Honor.
even without government subsidy.
Your Honor, again, kailangan talaga yung government subsidy.
Kailangan.
But
So,
of course,
kung walang government subsidy, nasaan ang Philhealth?
Your Honor, still in the year 2025, we operating PhilHealth, Your Honor, based on the programs that we are implementing right now, Your Honor.
Yes,
again,
and these programs are funded in full.
In the year 2025, Your Honor, available po yung pondo po natin, Your Honor.
Nasaan yung pondo? Binigay na ba sa inyo ng Treasury?
Your Honor, on existing funds of the corporation, Your Honor, our investable fund so December 31, 2024.
You know, my problem with your existing funds is this. You always do not consider the funds that should cover the reserve funds. That is my problem. Even though the command of Section 11 is for the reserve funds to be set aside. And when you set aside the reserve funds, it means it's real money. It's not just abstract. It's just not numbers. Because anytime the risk will become reality. That is my problem. Because you always do not recognize yet the funds that should cover the reserve funds.
Your Honor, if may I, Your Honor, in every year, Your Honor, we have the corporate operating budget, Your Honor. And this corporate operating budget, Your Honor, mayroon siyang kaakibat na corporate revenue as well. Kumbaga, may pumapasok na revenue. In the year 2024, Your Honor, our corporate revenue, enough or more than enough to cover the expenditures, Your Honor.
Expenditures, how about the reserve funds? The formula under Section 11 is this, right? Total revenues less expenditures. And the balance, that is where you will get your reserve funds.
Your Honor,
And your reserve funds, the amount should depend on the actuarial valuation for 2 years. Correct?
Your Honor, if may I, on the part of the accumulated revenue that we have, Your Honor, we set aside the reserve fund. Set aside na siya. Then, in the
What did you
operation,
say again, please?
na-set aside po natin. From the accumulated revenue.
So you are reversing the process prescribed by law?
Not necessarily, Your Honor.
That is what you were saying. Oh, reserve na agad siya. Hindi ba dapat accumulated revenues less expenditures? And then the total, the balance, that is where you get your reserve funds. And your reserve funds must correspond to the actuarial estimate.
Your Honor, mayroon ho tayong revenue that, of course, projected for a year. In that revenue, Your Honor, yun po ang ginagamit po din natin in sourcing out the expenditures po of the year. Meaning, the operation of the corporation for, say for instance, year 2025, much more dependent din pati siya, Your Honor, on the revenue po natin expected to be received for that particular year, Your Honor. So, ganun po siya, recognizing the revenue and then of course, the estimated expenditures po.
And then the balance will go to the reserve funds.
We'll go to the accumulated revenue, Your Honor, or the surplus that we have.
All right.
Yes po.
Okay. May I proceed to the next question?
Yes po, Your Honor.
So, did the transfer of 69.9 billion to the National Treasury make PhilHealth an economically viable guarantor of the people's access to quality and affordable health care and protection against financial risk?
Your Honor, the amount transferred to...
Can you just please go direct to the point? Yes or no?
Sorry, Your Honor. Again, Your Honor, 60 billion pa lang po na transfer po natin.
Pa lang?
Opo.
Konti lang, no?
60 billion po.
All
Not
right,
89
60
po.
billion,
Opo.
not 69?
Yes po.
O, ilan ba gusto nating i-transfer?
It is estimated, Your Honor.
All right, so
89.
what is your short answer to my short question?
Your Honor, sorry, Your Honor. PhilHealth's nag-operate si PhilHealth po, Your Honor, in the year 2024.
Did it help PhilHealth's financial condition? Did it upgrade your financial level when you transferred the 60 billion to the National Treasury?
Your Honor, despite the transfer, Your Honor, PhilHealth's investable fund from 498 in December 2023 and versus December 2024, Your Honor, of 492 billion.
So what is your answer, no? Or
Your
yes?
Honor,
Yes or no?
Your Honor, very sorry, Your Honor. Your Honor, PhilHealth operates the program, Your Honor, expanding the benefit payment.
All right.
Tumaas pa
So
siya.
I will go to my next question.
Yes po.
Did the transfer of this amount to the National Treasury reduce the deficit of PhilHealth in the amount of 663 billion plus in 2023?
Your Honor, if you are talking...
Just a straight answer,
Sorry
Mr. Senior Vice President.
I'm sorry, Your Honor.
Yes.
Apology po. Of course, Your Honor, the 60 billion that we transferred reduces...
Yes or no? Yes or no? My question is so simple and it is answerable only by yes or no.
Your Honor, it reduces, Your Honor.
It reduces the deficit, even though, yes, did I hear it right? Your transfer of 60 billion to the National Treasury reduced your deficit.
Your Honor, I think baliktad sa Your Honor. Because it reduces our accumulated revenue. And of course, kung sa total members' equity, Your Honor, tumaas pa siya, Your Honor.
You know, Mr. Senior Vice President, I really appreciate you. Thank you very much. Your excuse.
Thank you, Your Honor.
Chief Justice, thank you very much.
Thank you, Justice Javier. May we call on Justice Antonio Co for his interpellation.
Thank you, Chief. Can anybody answer questions on PhilHealth, please? Government Corporate Counsel, Hermosura, please.
Happy to answer your questions, Your Honor.
Okay, let us go to Section 11 again, the most popular provision in these discussions. Okay, Section 11 provides for what is known as the Program Reserve Fund. Before going to the details, can you give me the significance of providing a reserve fund for PhilHealth? What is the importance of having a reserve fund for PhilHealth?
As I understand, Your Honor, it's like a contingent fund.
A contingent fund to
Yeah,
for what
for-
purpose?
To address the possible lack of funding in the future.
So would you agree with me that the higher reserve fund you have, the more secure Philhealth will be?
Yes, that's correct, Your Honor. But at the same time, the law provides a mechanism so that
Within the mechanism provided for the actuarial.
yes, there's also a mechanism so that the managers of Philhealth do not become so conservative. So they cannot fix a reserve fund beyond the ceiling. There's a ceiling imposed by Section 11, Your Honor.
Okay, now let's go to Section 11. Section 11 speaks of accumulated revenues. It also speaks of reserve fund. It also speaks of current year expenditures. Can you define to me these terms?
Right now, Your Honor, there is an office order issued by the Philhealth President in 2012 where accumulated revenues is defined to mean the accumulated income of Philhealth. So it refers to the results of the operation of Philhealth in past years.
When you speak of accumulated income, that is net of expenditures for that particular year?
Yes, Your Honor. So it's
Okay.
net.
So if it is net, this Section 11 speaks of reserve fund to be taken from the accumulated revenues. And there's a formula under Section 11 wherein you determine the reserve fund.
It says, Section 11 says, the reserve fund, a portion of the accumulated revenues can be set aside as reserve fund, but which shall not exceed the ceiling, which is the actuarially estimated expenditures for the next 2 years.
Okay. Is it possible that the reserve fund will exceed as computed by the actuarial formula more than the accumulated revenues?
It is possible, Your Honor, but under that office order that I mentioned earlier, the reserve fund is always set as equal to the ceiling or lower than the ceiling.
Okay. The reserve fund under Section 11 is by virtue of the Universal Health Care Act, which was passed in 2019. Are you saying that prior to 2019, there is no concept of reserve fund by Philhealth?
No, there is already a concept, Your Honor. The concept of reserve fund was actually taken from the Universal Health Insurance Act, which was passed earlier. I think that was in 1995.
Okay. Now,
yes, 1995.
the prior to Universal Health Care Act of 2019, you said that there's already a concept of reserve fund.
Yes, that's in Section 27 of the National Health Insurance Act.
Is there a
of 19.
formula on how you determine the reserve fund prior to 2019?
No. The Section 27 of the National Health Insurance Act also says that from the accumulated revenues, a portion can be set aside as reserve fund, Your Honor.
What I mean is the 2-year actuarial computation. The ceiling.
That is the ceiling, yes.
Is that also present prior to 2019?
That is also in the law prior to 2019, Your Honor.
Okay. Now, for 2024, how much was the reserve fund?
2024. I think the board approved a reserve fund of 280 billion, Your Honor.
280
billion, more or less.
280 billion.
Yes. And
at the time, how much was the accumulated revenues?
I know it's more than like almost 500 billion.
The accumulated revenues.
Yes, Your Honor.
Is this 500 billion net of the reserve fund already? Is this net of the reserve fund?
The 500 billion revenue? No,
Yes.
no, Your Honor. So, the total accumulated revenue was around 500 billion, and then out of that 500 billion, 280.60 billion was set aside as reserve fund.
Okay.
So that left the 500 billion minus the 280 billion. That difference is the fund balance.
The fund balance.
But
Okay.
of that fund balance, which is like more than 200 billion, only 89.88 billion was required by the Department of Finance to be remitted by.
Okay, let's go to that later. Now, the 280 billion that is mentioned as the reserve fund of Philhealth, who determines that?
It's determined by the Philhealth Board, of course, but there is a recommendation from management, Your Honors.
Meaning, management probably computed by your Office of Actuary that could compute for the 2 years?
Yeah,
What is the basis of the recommendation?
Management makes a recommendation and the Philhealth Board approves, Your Honor.
Okay, how much was the recommendation made by the management of the Philhealth for purposes of reserve fund for 2024?
Oh, no. I have no info on that, Your Honor.
Can anybody from Philhealth office or department answer this? Actuary, please.
Oh. I have numbers here. I was provided numbers, Your Honors, but I think it doesn't respond to your question as to the number proposed by management. I think
Proposed
that's what-
by the actuary and if adopted by management and submitted to the board.
Well, the actuary only recommends, Your Honor.
Yes, but I want to know how much the actuary computed the ceiling corresponding the 2 years projected program expenditures.
Good afternoon, Your Honors.
Can I get your name, please?
Nerissa Santiago, the Acting Senior Vice President for the Actuarial Services and Risk Management Sector, Your Honor.
Okay. I'll repeat the question. For 2024, did you make any computation on the reserve fund, the ceiling corresponding to 2 years projected program expenditure for purposes of determination of the reserve fund?
Yes, Your Honor. During the December 31, 2023, we had a 2-year projected program expenditure set at 560 billion. That was the projected program expenditures for 2024 and 2025.
That was determined end of 2023.
Yes, that's correct, Your Honor.
So this 560 billion, is the ceiling corresponding to 2 years projected program expenditures.
Yes, that's correct, Your Honor.
After determining the 560 billion, what happened for purposes of looking at adoption by the board of the reserve fund?
That 560 billion is a part of the footnotes in the financial statement and is, I'm not sure if it was included in the presentation, but it is part of the financial statement, Your Honor.
Okay. Apparently, as explained by earlier, this 560 billion that you recommended was reduced to 280 billion.
Yes, that's
Am I correct?
Your Honor. Yes, that's correct. Your
Okay.
Honor.
So, why only, Mr. Counsel, why only 50%? 280 is 50% of 560. Why only 50% of the recommended amount did the board adopted as the reserve fund?
Actually, Your Honors, as you can see from Section 11, the requirement of actuarial estimate is only required for the ceiling.
Yes.
Not the reserve fund. So, where the actuary participated here was in setting the ceiling.
Yes, but you said earlier, you have 220 billion excess. Your expenditures accumulated revenues is 500 billion. The reserve fund is 280, and you still have 220 billion free funds. Why did the board merely agree or set the reserve fund 50% of the recommended amount?
The board has that discretion, Your Honor, to review the data and set the reserve fund to, or even the ceiling to reasonable levels. Yeah.
Okay, now, earlier it was mentioned that the reserve fund for 2024 was, as recommended, was determined on the last day of 2023. When, am I correct? Yes. Now, when did the board adopted the reserve fund for 2024 in the amount of 280 billion? Was it supposed to be the beginning of the year of 2024 or any time as long as it is within the year 2024? Is there a board?
Your Honors, may I surmise an opinion, or I don't know how they call it. I think this is in response to the GAA provision and the DOF circular when the discussion on the 280 was discussed in the board, Your Honor.
No, you mentioned that you made a recommendation in the end of 2023 that the reserve fund for 2024 should be 560B, right? And I presume the board were sufficiently informed of this amount. When did the board of Philhealth acted upon this amount to determine that the reserve fund should only be 280 billion? There should be at least a board resolution that would say that the reserve fund of Philhealth is 280 billion.
I think the board acted around middle of last year, Your Honor. But, yeah. By the way, previous to that, Your Honor, the board did not really, as I understand, I'm not really part of the management of Philhealth, but the board never really formalized any level of reserve fund. So they simply followed an office order that was issued in 2012, where they set the reserve fund equal to or lower than the ceiling.
Did I hear it right that the board did not actually made a reservation for purposes of this reserve fund?
No, in the past, Your Honor. But this is an info I'm getting from the board staff of Philhealth, Your Honor. But the board meeting for this new reserve fund that was approved was held May 8, 2024.
Can you provide us with the necessary documents to show, probably a board resolution, that on May 8, 2024, the Philhealth Board adopted a reserve fund in the amount of 280 billion?
We'll do that, Your Honor.
Can I get that commitment?
Yes, certainly, Your Honor.
Okay. Now, when the 560 billion, you computed it, you base this on 2 years projected expenditures, right?
That's correct, Your Honor.
On that basis, you came up with 560B.
That's correct, Your Honor.
And on that basis also, on May 8, the Philhealth Board adopted a reserve fund 50% as you recommended.
As stated, Your Honor.
Okay.
Yes.
Now, now let us go to, it was mentioned earlier that the amount requested by the Department of Finance, 89.9 billion, that was when it was sent to you that you need to transmit this amount. How did you go about it in PhilHealth? Was it immediately approved by PhilHealth? Did you have a discussion? What I mean is, under the GAA, it speaks of a reserve fund, right? Chapter GAA 2024, it speaks of reserve fund. In Section 11 of the Universal Healthcare also speaks of a reserve fund. Are these concepts the same or different from each other?
I think the reserve fund under the Universal Healthcare Act, Your Honor, has its own definition in the law.
Yes. In fact, under the Section 11, the reserve fund shall not exceed a ceiling equivalent to the amount actuarially estimated for 2 years projected program expenditures. So therefore, looking forward.
But
in the GAA, the reserve fund must be reduced to a reasonable level, taking into account disbursement from prior years. So therefore, the reserve fund under the GAA speaks of expenditures for prior years. So it speaks, these two concepts are different.
No, not really different, Your Honor.
Why do you say that?
You look at your past needs to, in a way, have a good guess of your future needs.
Again,
So
sorry.
you look at how you look at your expenditures in the past to have a good estimate of your expenditures in the future.
Yes, that is the reserve fund for PhilHealth. You determine that by taking into consideration expenses projected for the next 2 years, which is necessarily, from experience, higher than expenditures for the past prior years. So therefore, the amounts for reserve fund, if you compute it under the PhilHealth, would be vastly different from the amount of reserve fund under the GAA. In that case, my question now is, how did you compute the amount if there are two different bases in determining the amount to be remitted to the Department of Finance?
I know they took the rolling 2-year average of the expenditures in the past, was it 5 years, Your Honor, from 2018 to 2023. They took the average of the rolling past 2 years.
Okay. Now, when the GAA was passed, this provision on fund balance and the reserve fund, I'll read it to you. Fund balance of GOCCs from any remainder resulting from the review and reduction of that reserve fund to reasonable levels, taking into account the disbursement from prior years. So, under the GAA, they have to determine a reserve fund, right? And the reserve fund is determined by taking into consideration expenses for prior years, right? Okay. Now, when DOF sent you a request to send the money, 89.9 billion, how did you interpret this provision in the GAA vis-a-vis your own concept of reserve fund under Section 11?
The Philhealth, I know, has a manual of governance, Your Honor. So they went through a process pursuant to that manual. So one of the factors they considered is their absorptive capacity to spend. And that was based on the past years. I think they took the period from 2018 to 2023.
Who computed the amount of 89.9 billion?
That was the request from DOF, Your Honors.
Yes, precisely. So,
Yeah, so-
it was it from DOF that the amount of 89.9 billion came from?
I believe so, Your Honor. After
Okay.
they have determined that that 89.9 billion is outside the reserve fund. It will come from the fund
Can I
balance.
get somebody from DOF to explain to the court how this 89.9 billion came from?
Your Honors, Deputy Treasurer Ed Marino from the Bureau of the Treasury, representing the Secretary of Finance in the Board of Philhealth. The question is the calculation of the 89.9 billion.
How did you determine the 89.9 billion?
That is the unutilized subsidies as reflected in the unutilized government subsidies of PhilHealth for the years 2021 until 2023 as reflected in the financial statements of those years, Your Honor.
What do you mean by unutilized subsidy?
So in every year, Your Honor, from 2021 to 2023, there is a premium subsidy that was recorded in the financial statements of PhilHealth coming from the national government. And correspondingly, the accounting systems of PhilHealth can track the beneficiaries, the indirect contributor beneficiaries, where these subsidies must be used for. And we simply subtracted for each year the difference between the premium subsidies and the benefit expenses for indirect contributors.
So, since you contributed this much for 2021, 2022, 2023 representing subsidy from indirect contributors, those that were unspent or were not spent were taken back. That's what you're saying?
That is the basis of the 89.9 billion, Your Honor.
Okay. Now, however, under the GAA, this 89.9 billion, you will definitely tell me that this is part of the fund balance.
Yes, Your Honor. The 89.9 billion is part of the balance which is on top of the reserves, the reasonable reserves, Your Honor.
Yes. But under the circular, Department Circular 003-2024, there were guidelines that were provided for determining fund balance.
Yes, Your Honor.
Can you tell me where in these guidelines or what were the basis? Because in determining fund balance, it said here in 4.3, the reasonable level of reserve fund shall be computed by the DOF on a case-to-case, case-by-case basis, considering the following factors. It enumerated the factors, and I presume you know these factors. Now, you mentioned to me earlier that that the amount 89.9 billion represents the balance of the subsidy. Where in these guidelines or basis was the basis for taking up 89.9 representing this unspent subsidy?
Your Honor, I believe those one of the considerations highlighted there is the ability is actually the spending capacity of Philhealth, both in the past and the projected expenditures. So that is the primary basis. That is why we took a look at the financial statements of Philhealth. Moreover, the fund balance takes the form of cash in bank, and other investment securities. So that's the form included in the circular, Your Honor.
Yes, but I went through this 4.3. I do not see the basis for taking the subsidy, the unspent subsidy, as the 89.9 billion. Do you have a copy of Department Circular?
Your Honor, if I may just get a copy. Sir, if I may, Your Honor.
Go ahead.
Letter A of 4.3 states here, historical performance, including the absorptive capacity, which presents the actual financial performance versus the approved budget, regular and recurring operating expenses, including non-cash expenses, the legal claims and obligations, etc. Unutilized, and number K, unutilized subsidies and fund transfers for programs and projects, Your Honor.
So, by taking the unspent subsidy, you're referring to A and B?
Okay. So, the unutilized subsidy specifically is in K, 4.3K, Your Honor.
4.3K?
Yes.
Okay. So it refers to when you took the 89 when DFS requested the 89.9, it represents the unutilized subsidies.
Yes, Your Honor.
When you speak of subsidies that were given to Philhealth on 2021, 22, and 2023, why do you consider that unutilized? Because Philhealth is a going concern. And in fact, I understand for 2025, no subsidy was allotted to Philhealth. So why would you consider it to be unutilized subsidy?
Yes, Your Honor, if I may. Number one, for the past years, even for the years 2021, 2022, and 2023, Philhealth consistently receives premium subsidies in the GAA. It was the case in 2024. They were allocated about 40 billion in the 2024 GAA, and in 2025, the executive proposed, I think, in the NEF of about 80 billion in subsidies. So the reason, Your Honor, is because consistently the government, when DOF computed or evaluated the fund balance, the national government has demonstrated the capacity, the willingness to continuously provide subsidies to Philhealth. And of course, the mechanism in Section 37, the last paragraph, says that the DOH and Philhealth can provide the necessaries, can request the subsidies to help it achieve the goals of the Universal Healthcare Act. So it's a continuous flow, Your Honor.
Yes, precisely. So the fact that Philhealth could not spend this amount for benefits and the national government will take this amount to fund unprogrammed expenditures, the fault is on Philhealth for not spending this. It is not for the government to take this away and for Philhealth to expand its programs so that the subsidies that were allocated by government for healthcare should not be taken away. Instead of asking, directing the DOF, the national government, directing Philhealth, oy Philhealth, gastusin niyo ito para sa taong bayan, kinuha ninyo at binigay sa iba. This is precisely the meat of this case. So, why is Philhealth therefore not expanding their benefits and programs that would approximate the subsidies that were given to them to answer for the health benefits of our people?
Your Honor, if I may. So this is, of course, based on the discussions with management and my experience in the deliberation of the board. But fundamentally, Philhealth faces structural absorptive capacity issue. What does that mean? The benefits, expansion of benefits is only one part of the equation. To accomplish the objectives of the Universal Healthcare Act, we need, the national government also needs to address what we term as the supply side constraints, supply side issues. So ano po ba ito, Your Honor? So number one, the insufficiency of the compensation for our healthcare workers or healthcare professionals. Number two, hospitals, healthcare facilities. Even if there is even if benefit expansions occur, if there is no hospital within the vicinity of a specific beneficiary, particularly an indigent beneficiary, then they will not be able to avail of these expanded benefits. So there needs to be the supply side constraints. And of course, in addition to the direct health supply side health constraints, so yung hospitals po, yung medical equipment, and of course the personnel, the health care workers, you also have the WHO also has this term called the social determinants of health. So those are the other things. Those are the other things that help improve health outcomes. So what are these?
These things that you mentioned, absorptive capacity, the supply side issues, this can also be addressed by government. You're getting money from Philhealth and telling us that Philhealth lacks absorptive capacity. But the reason why it lacks absorptive capacity because it doesn't get full support from government, not only addressing expanding benefit, but also supply side requirements. So you're just providing an excuse to get this money out of Philhealth. No, when you speak of limitations in hospitals, I mean, you can inquire from our people, repeated complaints that they cannot even get Philhealth benefits. And if they get Philhealth benefits, it's so low that it cannot even cover substantially the amount expenses or medical expenses. So people will not understand the issue of absorptive capacity or supply side demand or requirements. So on the issue of why do you need to take this amount if the blame should be on Philhealth because it could not provide for these benefits?
Your Honor, if I may. So after the order or the instruction to return the 89.9 billion, we have seen last year that Philhealth has significantly accelerated the pace of benefit expansion, and they will continue to provide more benefits this year. So the issue in terms of the expansion of benefits is steadily being addressed.
Precisely that Philhealth increases benefits because of public criticism arising from this, trying to get the 89.9 billion. They are now probably justifying, oh, we can do this. In fact, we're increasing the amount. Without public backlash, probably, I don't know if Philhealth will increase its benefits.
That may be so, Your Honor, but all the same, I think for the Department of Finance, for the economic managers, what matters to us is the expansion of benefits. If there must be a stick, that must be presented together with the carrot, then we shall, I think we are happy if we see more benefits for the Filipino people.
Okay. Now, let us now go to the collection, the subsidy. The subsidy that were given to Philhealth were taken from the taxes, as mentioned earlier by Justice Ami, taxes from PAGCOR, etc. Now, when the budget for Philhealth subsidy from government, how do you compute the proposal of Philhealth for subsidy from government? Let us say for 2024. So may budget call noong 2023. Philhealth will have to prepare a budget, a request. For purposes of determining the subsidy that will be contributed by the government, what is your basis in determining the subsidy? Proposal to be submitted to the Office of the President for NEP.
Your Honor, if I may, I believe the exact process would be most familiar to DBM. But if you can allow me my basic understanding of the process. So Philhealth, during the budget deliberation period, they submit a proposed budget, and this proposed budget includes, number one, the number of beneficiaries.
No, initially, sa NEP pa lang. For purposes of preparing the NEP, the Philhealth will submit to the Office of the President a budget. Part of that budget is the amount of subsidy for indirect contributors. How much do you ask for, and what was the basis for this amount?
Your Honor, if I may, I'm not familiar on the exact amount, but in terms of the process, I know I am to the best of my knowledge, the proposal of Philhealth is put together with with DOH. So it's a DOH budget submitted to DBM for evaluation.
No, the reason why I ask this, we have laws that allocate funds to answer for the subsidy of government to Philhealth. Mentioned earlier, syntaxes, etc., etc. Now, do you know the actual collection of government corresponding to these taxes? And if you have computed this amount, do this equal to the amount Philhealth requested Office of the President for purposes of subsidy for indirect contributors?
Your Honor, I do not have with me the exact certifications from the syntax
I need to get an
allocation.
answer to this because this is in relation to the question of a special fund. Yung collection ng gobyerno sa mga taxes, PAGCOR, etc., for the year, ito rin ba ang hiningi ng Philhealth sa Office ng President para doon sa subsidy ng indirect contributors? For me, it should be the same amount.
I believe our colleagues from Philhealth or probably DOH would be in a better position to answer this on the exact amounts, Your Honor.
Good afternoon, Your Honor. Assistant Secretary Albert Domingo from the Department of Health.
Yes, please.
Thank you, Your Honor. To the question on how the Philhealth computes its request for a budget, it does not refer to the computation on the syntax allocation. Instead, it counts the number of members based on a database. There is a database on indirect members, and then it generates a list. It enumerates the number. The exact number escapes me now, but this is the process. and then that number is submitted, multiplied by a factor, which is the premium rate, and then it is submitted to the Department of
So
Budget
therefore,
Management.
when you come up with your budget request for the subsidy, you don't actually consider the taxes being collected that Congress passed for purposes of subsidy for indirect contributors.
That is correct, Your Honor. The budget is computed based on the need.
So they're not following the law? You're not observing what the law requires?
Your Honor, budget principles require that it's needs-based. If we will follow it based on the projected fund ceiling or availability, it might not match certain needs.
Yes, I agree. It's based on needs. But the problem there is PhilHealth limits the funding so that you don't address the needs, the health needs of the Filipino people. If you increase budget 200%, and I don't think the Filipino would not avail of that. You define your own limits. The Congress allocates budget or collects taxes, provides for collection of taxes to answer for the subsidy of PhilHealth for indirect contributors. Now, when you request money for subsidy, ang ibig mong sabihin, hindi mo papakailam yun? Hindi mo naiintindihin yun? Gagawa ka ng sarili mong formula because you have limited understanding there's a limited need of our people for health.
Your Honor, the current administration agrees with your observation, which is why this particular case under litigation has been the signal it has been using to increase the benefits. Ang tagal na po, 10
So
taon.
therefore, if the current administration recognize that, very thank you. And therefore, they should bring back the money back to PhilHealth.
Your Honor, the reason why the administration recognized it because for the longest time, the corporation has thought it will always get money because of the guarantee of the sin
Oh,
tax.
precisely, whatever would be. Whatever is that. As long as the government recognizes now, it is now incumbent on the part of the government to return the 60 billion that was transmitted already because it recognized now. Hindi lang na-recognize probably before, ngayon na-recognize na. So therefore, when you recognize it, you should return it. What do you think?
Your Honor, if it pleases the court, Section 58, the sovereign guarantee, even without this maneuver of the 89.9, government can and always will increase the benefits. But the signal, Your Honor, if it pleases the court, that this litigation gave is a strong signal for it to do so.
So the people should now be satisfied by a strong signal from the administration.
Your Honor, it's not necessarily the administration. It is the fact that the reserves, the amounts...
You said the government.
Yes, sir. Yes, sir.
So a strong signal from the government to help PhilHealth and expand benefit should now be enough for our people to rely on.
This is the start, Your Honor. If the case is allowed to proceed, if the transfer is allowed to proceed, it is a use it or lose it signal, which all national government agencies have, so that we will use our funds. GOCCs like PhilHealth do not have that signal, and they think, at least before the current CEO or the current administration, they think that just because there is an earmark, whether hard or soft, that they will get the money, and there is no stimulus for them to actually increase the benefits.
When you prepare this budget of yours for subsidy, why did you not consider the collection made by government, by BIR, on the sin taxes? What was the reason behind that?
Your Honor, mathematically, it's the premium rate. The way that the premium rate is determined, unfortunately, is not actuarially fair. It is not based on the spread of benefits that is due the Filipino people. Kulang po talaga yung binabayad ng PhilHealth. 10% lamang po in 2024. Kaya dapat po talaga taasan. And mathematically, the only way to do this is to increase the benefit packages, which we are doing now.
But the government collected taxes already, representing supposedly the subsidy. Why would government not transmit everything to PhilHealth as originally intended?
That is correct, Your Honor. Unfortunately, the receptacle to which this money can be transmitted cannot handle the amount of money because it's too small.
So if it is correct, and the reason why it was not transmitted because of administrative matters or hindrances, you agree that this should go to PhilHealth. It's a matter of spending it. So therefore, when government merely allocated this amount, probably substantially lower from the taxes that were collected. All of the balance should be given to PhilHealth this year and prior years. It's just a matter of administrative absorption. Hindi lang kaya gastusin ng PhilHealth. Kung hindi kaya gastusin ng PhilHealth, ibigay sa PhilHealth at utusan ng PhilHealth, oy, taasan ninyo ang benefits nyo. Hoy, mag-hire kayo ng mga tao ninyo para magastos ito para sa health ng ating tao.
Your Honor, if I may, 3 presidente na po ng Republika ang dumaan simula noong 2013 hanggang 2023. At siguro mahigit 10 mga presidente ng korporasyon. Ganun po lagi ang utos pero hindi po nangyayari until now.
Probably it's time to overhaul PhilHealth and change the board for not complying what the law requires. Hindi kasalanan ng tao yan. For not availing all of these benefits. Apparently, from your own words, kasalanan niya ng administrasyon, this administration, last administration, or the previous administration. At kasalanan niya ng PhilHealth Board. Huwag natin pahirapan yung tao because nandyan naman yung pera. The money is there, government actually collected this, and you're not giving it to PhilHealth to serve as health benefits for our people.
If I may, Your Honor, in fact, nung una pong oral arguments, iba po yung PCEO na humarap sa korting ito. At nung ikalawang oral arguments, ganun ho kabilis, iba na ho uli yung humarap na CEO. Kino-correct na po.
Okay, so that's maybe a good point from PhilHealth, but we cannot close our eyes for the past years na hindi nabigay in benefits. So in that case, maybe PhilHealth can already request the President to return the money, the 60 billion that were transmitted to PhilHealth, to the government for Anchor Program funds. Ibalik na yan sa PhilHealth and PhilHealth to expand its benefits, hire more people to answer for the needs of the health of our people. That will be all, Chief. Thank you.
Thank you, Justice Ko.
Your Honor, please, if I may raise a factual matter, Your Honor. I'd like the court to know that PhilHealth has not been actually disadvantaged by its not demanding the allocation from the sin tax law. Because in fact, I have here the numbers, Your Honor. From 2013 to 2021, PhilHealth has actually been receiving subsidy from the GAA more than what it would have received under its allocation attributed from sin taxes, Your Honor. For instance, in 2014, the PhilHealth allocation attributed from sin tax is only 22.71 million, but the total PhilHealth subsidy was 35.34. So let us say in 2021, PhilHealth allocation attributed from sin taxes was 16.92, and the total PhilHealth subsidy was 80.24. So there is no truth, Your Honor, to the claim that yes, that's what I have here, Your Honors.
So, but you mentioned only sin taxes, but there are other sources of the subsidy aside from PAGCOR and etc. So when you total this, I would think it should be more than the subsidy because government has limited funds. Kung ito lang ang collection under the law for subsidy, I doubt the government will allocate additional funds. So kukuha lang yan dun sa funds allocated under the law, whether PAGCOR, whether sin taxes, at dun lang kukunin yan. It could never be more than because government has limited resources. Saan niya kukunin yung balance?
These are numbers that I got from our Bureau of Treasury, Your Honors. And by the way, if I may mention, there is actually an interagency committee composed of the Department of Budget and Management, Department of Finance, Department of Health, PAGCOR, PCSO, and the Philippine Health Insurance Corporation. created under Joint Circular number 001/2022, where they monitor the allocations for PhilHealth from the syntaxes, from PAGCOR and the PCSO. I would think that they make
Counsel, in order to settle this matter,
Yes, Your Honor.
can you please submit to the court the collection made by government under
Section 37.
the syntaxes, the PAGCOR, the PCSO, vis-a-vis the subsidy given by government? Doon natin makikita. We can see there if actually the amount collected is lower than the subsidy given to government.
We will do that,
To
yeah,
PhilHealth.
Your Honor.
Can you please
And-
submit that
yes.
for the past 5 years?
And if I can also plead, Your Honor, for the court to be more understanding of PhilHealth for its its inability. I think what it was referred to as lack of absorptive capacity earlier, because we must understand, Your Honor, that the PhilHealth funds are not like discretionary funds. They can only be spent after PhilHealth has adopted the programs, goes through a process of developing adjustment to benefit packages.
Basta pwedeng gastos.
Thank you, Counsel.
Thank you, Your Honor.
Thank you, Justice Ko.
Thank you, Chief.
May we call Justice Japardi Mampao for his interpellation? Go ahead.
Thank you, Chief. May I ask the counsels for petitioners in GR numbers 274, 778, and 276, 233 to answer these questions on procedural issues.
Good afternoon, Your Honor.
Good afternoon. Under Article 8, Section 5, Paragraph 2, Subparagraph E of the Constitution, the Supreme Court exercises original jurisdiction over cases in which only a question of, in which only an error or question of law is involved. Relatedly, the Supreme Court previously decreed that funds levied for special purpose can only be paid out for such purpose. This was the ruling of the court in the case of PCGG versus Cocopet, jar number 147-062, promulgated on December 14, 2001. In this case, the special fund in question is the 80% allocation from sin tax collections. However, it cannot be said that Philhealth funds, particularly those determined as fund balance, do not exclusively come from the sin tax collections. In this regard, would not your petition involve a question of fact that would require the court to receive evidence to determine the portion of that fund balance of Philhealth that pertains to the government subsidies from sin tax collections?
The question is if this is a factual issue, Your Honor. Well, we submit, Your Honor, that this is a legal issue of whether or not the reserve funds under the GA should be transferred contrary to the express provisions, Your Honor, of the Universal Health Act that reserve funds should not be transferred back to the National Treasury.
You mean to tell us that such portion of the Philhealth fund balance can be determined from that 80% allocation from sin taxes without presenting any evidence
Your
to
Honor,
that effect?
the express provisions of the GAA, Your Honor, refers to reserve funds, Your Honor. And the express provisions also of the Universal Health Code refers to reserve funds. So we are of the opinion, Your Honor, we submit, Your Honor, that these contrary opinions, these contrary rights, Your Honor, is the actual case or constitutional case in question, Your Honor, that the provision is contrary to law, contrary to the Constitution, also that the transfer also of the fund authorizing the Department of Finance to transfer is likewise unconstitutional because only the Constitution only allows the President, the head of the legislature, the chief, and the constitutional bodies to transfer reserve funds from one department to the other, Your Honor.
Are you in effect invoking the ruling of the court? In the case of Jusamar versus the OTC, wherein the court emphatically declared that the determinative test in raising a petition before the court is that it must raise a question of law.
Yes, Your Honor, part of it is a question of law and the actual case in controversy, Your Honor. In such case, the actual case in controversy, in this case, Your Honor, as stated, is the conflict of rights between the Constitution alleged by the executive and the legislature to transfer funds vis-a-vis the express provision of the Constitution limiting the transfer of funds to the certain individuals and also of the express provisions of the law prohibiting such transfer of reserve funds back to the Treasury.
Do you consider this case before this court as one of transcendental or paramount importance?
Yes, Your Honor, we submit that in our pleadings, Your Honor, that it is of transcendental importance and that the transcendental importance have given due course by this honorable court in a number of cases. And the health and welfare of the people, Your Honor, the transcendental importance of the basic right to health has been actually passed upon by this court in the case of Imbong, Your Honor.
May I now ask you substantive questions? Petitioners in GR numbers 274, 778, and 276, 233 argue that Section 1, Paragraph D of the 2024 General Appropriation Act and the Department of Finance Circular 003-2024 are unconstitutional for being violative of the constitutional right to health enshrined in two constitutional provisions. Article 2, Section 15, which states that its state shall protect and promote the right to health of the people and instill health consciousness among them. The second one is Article 13, Section 11, which provides that the state shall adopt an integrated and comprehensive approach to health, which shall endeavor to make essential goods, health, and other social services available to the people, to all the people at an affordable cost. In the landmark case of Embong versus Ochoa, GR number 204819, promulgated on April 8, 2014, the Supreme Court categorically declared this as self-executing provisions, and there is no need for legislation to implement the same. Still and all, it bears noting that the so-called threat to the right to health is rooted in the actions of both Congress and the Department of Finance that appear to stymie or impede the timely implementation of the universal health care system. Does the characterization of the constitutional right to health as self-executing provision mean that Congress would no longer have discretion to determine how it should promote the same?
Your Honor, the express provisions of the Universal Health Care Law is very clear, Your Honor. The specific amounts to be given to the health care is basically outlined in the Universal Health Care Law, such as already mentioned, taxes, PABCOR, PCSO. That is not for the Congress to decide, Your Honor. That has already been passed. Second, Your Honor, the provisions of the Universal Health Care Act, Your Honor, is very clear as to the benefits and provisions and how the reserve fund would be spent should there be any excess, if any. In addition, Your Honor, we also agree that the GAA, contrary to even with the DOF circular, is again contrary to law and does not go with the intent of the Constitution for as you said, automatic implementation of health care for the Filipino people. So we submit, Your Honor, that again, even without the law, it is automatically given, but with the implementation of the law for both the universal health care, then it not only automatically gives it, but the specific provisions and amounts are very clear and should be followed, Your Honor.
Though these constitutional provisions necessarily entail the implementation of the universal health care system such that any threat thereto can be deemed violation of rights or the Constitution?
Your Honor, if I may, the Universal Health Care Act was primarily passed in pursuit of these constitutional mandates. Aside from the Universal Health Care Act, there are actually other laws that were passed to so that these constitutional mandates are met. Your Honor, while the language of the Universal Health Care Act is clear, we also take note, Your Honor, that what the government did by removing or getting again the money they originally gave as subsidy for premium contributions of the indirect contributors, Your Honor, is a retrogressive measure, which under, and I believe was mentioned earlier, under the WHO and the UN documents, is actually, Your Honor, a violation of the right to health.
Let's talk about Philhealth funds. Do you adopt the postulation that Philhealth funds are public funds?
Your Honor, no. The funds that goes through Philhealth, Your Honor, even the premiums from the indirect contributors actually loses its character as a subsidy, Your Honor, precisely because of the social insurance scheme wherein there will only become one fund. And this fund will be used primarily for health services or for the health needs of the people, Your Honor. Despite the fact, Your Honor, that the indirect contributors' premiums are paid for by the government, there is a social, I'm sorry, Your Honor, when the The original Philhealth law, which was Republic Act 7875, was first amended in 2013, I believe. There was a clear mandate that there is a social contract between the government and the people, wherein the government will have to pay for the premiums of those who cannot afford to pay, while those who have the capacity to pay pays for their own premium. And the government, by removing the at least 60 billion, Your Honor, as of this date, the 60 billion removed by the government from the indirect funds are actually a violation of the one fund policy that is the basic concept of a social health insurance, Your Honor.
Do you recall the authoritative definition of public funds? The Supreme Court had occasion to define public funds in the case of Confederation of Coconut Farmers Organizations of the Philippines, Inc. versus Aquino III, CR number 217965, promulgated on August 8, 2017. There, the court defined public funds, and let's check whether your theory is correct. Now, I will define public funds in the manner the court defined the same. Public funds are monies belonging to the state or to any political subdivision of the state, more specifically taxes, customs duties, and monies raised by operation of law for the support of the government or for the discharge of its obligations. Do you admit that these health funds may come from taxes?
Your Honor, there are taxes levied for the indirect contributors. We agree, Your Honor. However, there are also private funds coming from contributors from private entities, such as everybody here in this room, Your Honor. And the one fund concept would put it into, I would say, a trust fund, Your Honor, contrary to a public fund strictly stated by the Honorable Justice, Your Honor.
Under Republic Act 10351, otherwise known as the Syntax Law, it provides that 80% of the syntax collection, of the balance, the remaining balance that may be derived from syntax collections, derived from this act, shall be allocated for universal health care under the National Health Insurance Program. So how do you make sure that you insist that health funds do not qualify for the category of public funds?
I think Your Honor, this is more of a phase fund. It's a commingled fund between the public and private funds, Your Honor. It's not only private funds sourced from taxes, but this is actually sourced from private members, Your Honor, private individuals, giving their taxes and their contributions, Your Honor. And if I may, Your Honor, I would just like to add, Your Honor, that the premium contributions of the private contributors having exist through the years, contrary to the social assistance funds, at the end, if there's any fund, fund as the government being Philhealth only a trustee in possession of the trust fund given by the beneficiaries and the contributors for Philhealth.
Now let's talk about special fund. The reserve fund mentioned in Section 11 of Republic Act 11223 as Universal Health Care Act. Can you consider that as a special fund?
Yes, Your Honor. It is a special fund, Your Honor, because it is for a special purpose.
The fund that is derived from the sin tax collections, will that qualify as a special fund?
Yes, Your Honor, because under the Republic Act 11346, which amended Republic Act 10351, the law specifically mentioned that these funds, the percentage, the 80% of the total collections must be used exclusively for Philhealth, for universal health care under the Philhealth.
Do you recall or are you aware of a jurisprudential ruling regarding special fund? I'm asking about decision of the court.
I believe, Your Honor, the mention earlier about the case of COCOFED versus
Yes.
Aquino discusses the special fund, Your
Although
Honor.
that pertains to COCO-levy funds. Now, what's the ruling of the court in that case? COCO-levy funds, according to the Supreme Court, are special funds allocated for a special purpose and cannot be used for other purpose other than for the benefit of the coconut farmers or for the development of the coconut industry. That's the ruling of the court. Can you apply that to this case?
Yes, Your Honor.
Yes, Your Honor. Yes, Your Honor. In the same line, Your Honor, the special fund for the health or welfare, health and welfare.
Even after it has been allocated for that purpose, special purpose?
Your Honor, the special fund as collected, once given to Philhealth, should be allocated for the health and welfare of the Filipino people, the beneficiaries, both direct and indirect beneficiaries, Your Honor.
The 2025 GA has recently been passed into law. Has that provision on fund balance of the government-owned or controlled corporations been carried over?
As per our checking, Your Honor, it is not carried over in the 2025 General Appropriations Act, Your Honor.
The petitioners claim that this special provision of GA 2024 is not valid or void because it violates a statute, specifically Section 11 of the Universal Health Care Act, Republic Act 11223. But if you read the provision, it does not mention about Philhealth Fund. It merely refers to government-owned or controlled corporations in general. If you read the Department of Finance Circulars 003-2024, it likewise does not likewise mention about Philhealth. It is only mentioned in that letter to Philhealth. In your petition, page 16, I refer to petition year number 274778. You only mention that, Exhibit E, Annex E. Now, my question is, from this instance, given this foregoing, are you not questioning the implementation of the law rather than the constitutionality of the law?
In our submission, Your Honor, we asked the constitutionality of the law because the DOF circular allows the implementation of the GAA and allows the Secretary of Finance to transfer funds from one department to the other. Constitutionally, Your Honor, as already mentioned, only the President under the executive may transfer funds from one department to the other and not the Secretary. We would also like to put on record, Your Honor, under our petition, we have a letter to the Secretary dated 27 August 2024, specifically asking that said transfer would be illegal and should not be implemented. And until today, Your Honor, we have no answer to our letter, Your Honor, addressed to the Secretary.
Suppose we harmonize this provision in the 2024 GAA with this law, Universal Healthcare Act, and this reserve fund should remain untouched. Would you still claim that there is improper implementation of the law?
We submit that we cannot harmonize. These are two conflicting provisions, Your Honor. It cannot be harmonized because specifically stated that it is only for the purposes intended. And if they are trying to skirt the law by passing the GAA and putting a provision that would allow a transfer to us that cannot be statutorically harmonized, Your Honor, and the GAA would be violative and invalid, Your Honor.
Thank you. May I now ask Chairman Lazaro-Javier Colmenares, because in your petition you raise this President certification and this bicameral conference committee. Am I correct?
Yes, Your Honor. Thank you.
I could vividly recall last February 25, you manifested in my petition, I raised these two issues. Now I will ask you on this.
Yes, Your Honor. Thank you, Your Honor.
Article 6, Section 26, Paragraph 2 of the Constitution provides that the President may certify to the necessity of the immediate enactment of a bill to meet public calamity or emergency. Do you know the case decided by the court which delved into this certification by the President regarding the urgency of a bill?
Yes, Your Honor. Well, if you're referring to the case of Tolentino, Your
Yes,
Honor, it was cited there.
Tolentino et al. Versus Secretary of Finance, 115455, promulgated on August 25, 1994. The basis for such certification has been challenged in that case. And this pertains to the certification of the urgency of the passage of the expanded value-added tax law, Republic Act 7716. The court found that the Senate did not find any need to controvert the same, and in fact, it accepted such certification. My question is, the House of the Philippine Senate and the House of Representatives sitting in plenary accept that certification of the President in this case?
Yes, Your Honor. From the records of the House and the Senate, the House and the Senate accepted the certification of the President, there are objections, of course, Your Honor, from some senators. But I think, Your Honor, the issue of whether or not the House or Congress accepts the certification is not going to overturn a constitutional violation. In this case, Your Honor, while the President has the discretion to issue a certification of urgency, Your Honor, it's not a boundless discretion, Your Honor, that the Constitution, because the Constitution put in parameters, Your Honor. The first is that there is a public emergency or a calamity, Your Honor. And second, there is a bill that meets this public emergency and calamity. And third, there is a need for the immediate enactment of this bill to meet such calamity. So therefore, Your Honor, in our interpretation, the President must follow this. Notwithstanding whether Congress agrees with it or not, if the President did not follow the parameters under the Constitution. For example, he issued a certification absent any calamity or emergency, or he certified it despite the fact that there is no immediate enactment of the bill, then for us that is violative of the Constitution, Your Honor. So in this case, we argue that the President issued the certification, but from the records of Congress itself, there was no emergency or calamity to speak of. And Your Honor, the reason for our interpretation of this, other than the fact that the certification did not mention any calamity, so that at least Congress can exercise its discretion to accept or not accept the certification, the timeline itself, Your Honor, from congressional records show there was no calamity. They approved the bill, Your Honor, on second and third reading on September 27 of 2023. And then they had a recess on September 30 of 2023. They did not transmit the bill to the Senate despite the fact that it's supposed to be an emergency or public calamity. They only transmitted it, Your Honor, in November. So they approved it on September 27. They deviated from the constitutionally required legislative process. But then after all the rush, Your Honor, they took a recess. And then they transmitted it November 4. Then we realized later on the reason for that hiatus is because they formed a small committee to amend the bill already approved on third reading, Your Honor. So that was the reason why they had to wait for November 4. Publicly, the small committee declared, oh, don't worry, the small committee will finish all the amendments by October 10. But then they failed, so it's November 4. Then there is the BICAM, Your Honor. Then they created a technical committee. All these things, Your Honor, we believe, does not show emergency or a calamity, Your Honor. And secondly, Your Honor, if Congress is going to delay the approval of the budget on the basis, oh, we're going to have a recess, we're going to form a small committee, and so on, it is a self-created emergency, Your Honor. The President cannot certify a self-created emergency. Ginawa nyo yun, bakit ako ang magsicertify sa kasalanan nyo? It cannot even be a preemptive emergency, just in case Congress will not be able to pass it in December, so I'll just issue a certification in September. It cannot be preemptive, Your Honor. The certification of the President as to a public calamity or emergency must be existing at the time of the certification, Your Honors. So, in that case, Your Honor, the President or the certification violated the parameters of the Constitution. There was no calamity. There is even no immediate enactment, Your Honor, because whatever the President do, it will only take effect on January 1 of 2024, so much so that whether or not he certifies it, the immediate enactment is not forthcoming as required by the Constitution, Your
Having
Honors.
said a while ago that it was accepted by the Philippine Senate and the House of Representatives, is that not within the realm of, are you not questioning the legislative wisdom behind such acceptance of that certification?
Your Honor, no, Your Honor, because legislative wisdom can only be considered if there is no violation of the Constitution. In fact, Your Honor, this is very strange. Presidents issue certification. They did not explain to the Congress what calamity I'm addressing, how will this bill meet the calamity, and yet Congress blindly follows a certification. I have a suspicion, well, beyond this case, Your Honor. In fact, it was probably Congress who requested the President for them to exercise that discretion. They must be made aware, ano ba itong emergency na sinasabi ng Presidente?
Now, let me now ask you about bicameral conference committee. Do you recall decision of the court that made mention about this BCC, bicameral conference committee, Abacada Guro part list versus Ermita?
Well, I've read the
GR number 168056 promulgated on September 1, 2005.
Yes,
The
even
Supreme
Tolentino
Court,
mentioned that, Your Honor.
said in that case that this BCC is mandated. The court, in effect, recognized that to settle these diverging or disagreeing provisions in the House and Senate bills.
Yes, Your Honor.
Are you against this BCC or bicameral conference committee?
No, Your Honor, as long as they follow the Constitution. In the Constitution, for example, Your Honor, appropriation bills should exclusively originate from the House. And the role of the Senate is to propose amendments to the bill. 281 billion unprogrammed fund from the NEP submitted by the President, 281 approved by the House, 281 approved by the Senate. The Senate did not propose any amendments to the 281 billion. Suddenly, Your Honor, the BCC proposes 431 billion, half a trillion, Your Honor, of items and projects in the unprogrammed fund. So did that originate from the House? No, Your Honor. It originated from the senators and the members of the House in the BCC. Was it the proposal of the Senate? No, Your Honor. The Senate did not propose amendments to the 281 billion. So even the senators in the BCC have no power to propose amendments. The BCC, Your Honor, cannot propose amendments to that already approved by Congress and the Senate because the BCC is not the Senate. And the Constitution says the Senate may propose.
You mean that BCC cannot introduce new provisions?
They can introduce harmonization, as you mentioned, Your Honor. If Congress says 281 billion and the Senate says, let's make it 300 billion, the BCC can now harmonize the two provisions. But in this case, Your Honor, the House said 281, the Senate said 281. So where did the 739 billion come from? It came from them, Your Honor. So they have no authority to propose it. This is ultra vires, Your Honor. It did not originate from the House. It was not a proposal of the Senate. If it's ultra vires, no amount of ratification, Your Honor, can cure an unconstitutional act.
Okay,
Thank you, Your Honor.
I got your point. Let me ask you about the application of this very popular doctrine of operative fact.
Yes, Your Honor.
Assuming that your petitions are deemed meritorious, will the application of this doctrine of operative fact prohibit the return of the money transferred to the National Treasury?
Well, Your Honor, of course, it's at the discretion of the court. But for us, at the very least, the 479 billion of new items inserted by the BCC should be returned. And those funds which were spent with bad faith, for example, Your Honor, there was a TRO issued, and yet the Philhealth funds transferred were still spent despite the TRO or after the TRO, and I think they should be returned. The entire Philhealth fund should be returned, Your Honor. Well, the 479 billion, Your Honor, if there is corruption attendant to the bills, I would like to think that they should be returned, Your Honor, at the very least. But we leave it to the discretion of the court in this case because ito yung problema, Your Honor. They placed us in a corner. Gawa-gawa ng iilan, everybody's affected. I mean, if you're going to ask would the entire budget must be voided, then everybody's affected, even the court. Gawa-gawa ng iilan, lahat tayo, ngayon nakalagay tayo sa pader, Your Honor. Kaya minsan mapilitan na lang tayo mag-operative fact. Siguro, Your Honor, if the court is going to exercise the operative fact doctrine, at the very least, the parameter should be issued para wag nang ulitin. Kasi otherwise, pag inulit nila yun, Your Honor, malagay na naman tayo sa alanganin, mag-operative fact na naman ulit tayo. They've cost hundreds of billions of pesos to the Filipino people. And lulusot lang sila because of the operative fact, nagastos na namin. I mean, Your Honor, I am now in no conscience to say na sige na tanggalin, ibalik lahat yan. Siguro the court will have to do this as declared by the court, sparingly, case-to-case basis. But for me, if there's bad faith, if there's corruption, the court must order its return, especially the entire Philhealth Fund. For example, Your Honor, 89 billion, that's clear from the questions of Justice Co. And other funds that may have been attended by corruption, Your Honor. In any case, Your Honor, whatever is the decision of the court, if there is an irregularity or corruption, people must go to jail. People must be charged for this insertion of 500 billion peso in the budget of the program appropriation, merely because it's their whim, not because the House said so, not because the Senate proposed it, but because they felt they know of items that nobody ever thought of, not even the President, not the House, not the senators. They, by their lonesome, the BCC senators and the House of Representatives thought of these items that nobody thought about. For us, Your Honor, that is not only arrogance, that is a usurpation of the powers of both houses of Congress, Your Honor.
This is what the doctrine of operative fact says. It nullifies with law, but sustains its effects.
Yes, Your Honor, in exceptional circumstances, Your Honor.
So it does not apply to this case?
It is the court's discretion to apply. But at the very least, Your Honor, we would like to assert at least yung 479 billion. Sana masoli man lang yun. Kasi talagang void yun eh. Ultra vires talaga, Your Honor. But of course, we leave it to the court. Ang limit lang namin, Your Honor, is this. At least the billions of pesos taken from Philhealth and the billions of pesos taken from PDIC, I heard it, I read it's 100 billion pesos taken from the Philippine Deposit Insurance Corporation. They should be returned, Your Honors. Because these are very important to the right to health, as my co-petitioner said, and even the security of depositors, Your Honor. You take 100 billion pesos more than what was taken from Philhealth in PDIC. These things, Your Honor, there must be a lesson taught here, Your Honor. And they must be, the court may order the return. It is the burden of the respondents to prove that they did it in good faith, there was no irregularity, no corruption. Then the court may, of course, we submit to the court's discretion on this matter, Your Honor.
Thank you. May I now ask the
Thank you, Your
counsels
Honors.
for respondents?
The PhilHealth funds was not discussed in relation to operative fact. Can we add to what my colleague has pointed out? The operative.
Proceed.
Yes, Your Honor. Thank you very much. The operative fact doctrine is based on the court says it should look at the effects and rule based on equity and fairness because it's a rule on equity. So you have to show the one who implemented the law, did they do so in good faith? We will point out the government's action have budgets of bad faith. But before that, Your Honor, let's also look at the effect. Is it equitable? Is it fair to the people when they took away the PhilHealth funds? Clearly, it's not, Your Honor, because the law clearly says those funds are for the health of the people. And our people, if we look at PGH, just right in front of the Supreme Court, early in the morning, hundreds of people line up because they cannot afford health care. They have to line up in our government-funded hospitals because they have no choice. PhilHealth should have provided that choice. So it would be inequity if we do not return the money. Now, Did they took the money in good faith? No, Your Honor. Why? The law is clear. They should not have taken it. Then we go to COA. Let me point to the COA observations published in the COA website for GOCC's 2023. Your Honor, when they took the money from Philhealth, it was actually triple whammy on the Philhealth members. Why? Number one, they took the money in contravention of the law. Number two, when they took the money, their computation was wrong. The COA was saying the 89.9 billion, even assuming the computation is correct, is even assuming that their formula is correct, rather.
May I remind you that my time is very limited.
Sorry, Your Honor.
Please expound that in your memorandum.
Yes, Your Honor.
Please.
Thank you very much, Your Honor, for giving us the opportunity.
Thank you, thank you. May
Mr.
I
Counsel?
now ask the
Mr. Counsel, may I call your
counsels
name?
for respondents.
Anong pangalan niya? Mr. Ocampo? Mr. Ocampo, next time you seek the permission of the court before you speak. You just don't butt in there. Thank you. If that's the case, then let's have a recess. We resume after 30 minutes or 20 minutes.
Thank you, Chief.
May I call on Justice Jolo to proceed with his... sorry, you still have questions? Okay. Okay. Go ahead, Justice Japs.
Thank you, Chief. May I ask the counsel for the respondents to answer my questions. Attorney Solomon Hermosura, will you please come forward? Either of you may answer the questions. The contentious provision in this case is Section 11 of Republic Act 11223. That's the Universal Health Care Act, which says that, open quote, Philhealth shall set aside a portion of its accumulated revenues not needed to meet the cost of the current year's expenditures as reserve funds. Close quote. It is evident that the law uses technical terms. We ought to clarify the situation or what is happening. We must demystify these technical terms for the court's clarity and understanding. To simplify the discussion, I have prepared a PowerPoint presentation. First, let's try to understand the meaning of accumulated revenues. Last week, February 25, COA Commissioner Douglas Malilin espoused the view that accumulated revenues refers to premium contributions and government subsidies less normal operating and administrative expenditures and claims benefits. Do you agree with that definition?
Your Honor, I believe that is essentially correct, but if I may add, to include also income from investments.
Income from
Investments. Yes, Your Honor.
Let's be basic. If you consult the Black's Law Dictionary, this is what it says. It refers to total income that has been collected over a certain period. That is how the Black's Law Dictionary defines accumulated revenues, given that Republic Act 11223 does not define the term. Neither can you find a definition in Section 4 of the implementing rules and regulations of Act 11223. So with that revised definition, you agree with that definition. Now, having clarified the meaning of accumulated revenues, by the way, those who are listening as law students, revenue is to the government, income is to the taxpayer. That's a basic distinction of corporation. Revenue, for the benefit of those who are taking up taxation, may include not only taxes, but other sources of governmental income that may include fines, the enforcement of laws, fines, penalties, that may form part of revenues. Now, having clarified the meaning of accumulated revenues, let's now examine what the law says. Not needed to meet the cost of current year's expenditures. So, from this provision, we really have to deduct that cost of current year's expenditures. My question is this cost of current year's expenditures in light of no clear definition of the term in Republic Act 12223, the same as that cost of normal and administrative expenditures in the previous slide?
Your Honor, my understanding about current expenditures are the current, present, this year's operating expenditures of Philhealth. So that includes not only the administrative cost of running Philhealth, but also, and more importantly, the claims that it has to pay, the benefit packages that it has to promote. That is my understanding, Your Honor, of current or present expenditures. And if I may add, while we talk about current expenditures, we should also take note that currently there will also be income flowing in at the same time that current expenditures are being made.
Is it accurate to say that the difference of accumulated revenues and the cost of current year's expenditures is the reserve fund? Is that an accurate statement?
Well, let's say for this year, Your Honor.
No, just answer that. Yes or no?
The reserve fund is taken from the accumulated revenues over the past years.
It's not accurate because, as the law says, portion.
Yes, a
So
portion.
that reserve fund is just a portion of the difference between accumulated revenues and cost of current year's expenditures. Now, since the reserve funds is just a portion, let's level that as X. So how do you now term that X? Can you think of a term that will describe the difference between accumulated revenues and cost of current year's expenditures, given that reserve funds is just a portion of that. Can you think of a term in as much as the law does not mention any term about such difference? Can you think of a technical term that will represent the difference between accumulated revenues and cost of current year's expenditures?
No, actually the current year's expenditures are matched against the current year's revenue, Your Honor.
Can we use this word excess? Excess. In the absence of a clear-cut term, excess of accumulated revenues and cost of current year's expenditures, from that excess, a portion forms part of the reserve fund.
Yeah.
Do you agree with that?
Actually, the COA also uses the term surplus, Your Honor.
Okay. Last week, I heard the word gap. There is a gap. Now you are espousing a theory that should be termed as surplus. The literal term is excess. Is the word surplus appropriate to describe such excess? What do you mean by surplus?
Well, I think maybe excess is not being used because when you say excess, it's like you have money that you should have that you don't need. But this is money that is actually also put into use, Your Honor.
Let's consult Black's Law Dictionary and tell us if the definition fits your theory. The Black's Law Dictionary says surplus is the remainder of a fund or a thing that has been set aside for a specific purpose. Do you think that will fit that appropriate term?
I am looking at actually at Office Order number 0145 series of 2012 of the Philhealth, Your Honor, and actually it defines surplus as a situation when the current year revenue exceeds the current year expenditures.
Okay, in any case, since the law provides no clear term that will describe that excess or surplus, as the case may be, so when it says portion, so there is that other portion. Do you agree?
Yes, Your Honor.
Okay, so we can label that as Y. Now, can you think of a technical term that will describe that other portion? So, literally, it's other portion because the portion reserve fund is another one. So let's label it as Y. We term it as other portion.
Actually, we can replace that diagram with, like I say, Your Honors, a circle, like a pie. So the pie represents the total accumulated revenues. That total accumulated revenues, you can slice it into parts. One part is called the reserve fund. So in this case, the total pie is 500 billion. And then you take a slice of that total pie, make it into the reserve fund. That's the 280. So therefore, and then the remainder of this pie, that's the fund balance, actually.
Fund balance?
Yes.
So you mean that Y can also be considered as fund balance? Why?
Yes, that's correct, Your Honor. Because, one way to look at this, Your Honor, is because as I mentioned, there is this office order of the Philhealth that set the guidelines on how they apply this reserve fund.
Yes, but I think, with all humility, this is the simplest way to interpret the provision. When it says portion, so reserve fund is just a portion, so there must be other portion.
That's correct. Yeah.
So
why?
can we consider that as savings, as spouse? I could vividly recall by the Solicitor General, it's not a special fund, this may come from savings.
Your Honor, savings has acquired a definite technical meaning in the GAA and also in jurisprudence. So savings actually refer to those amounts which form part of appropriations, but which have now been saved, so to speak, because of efficiency in operations or because the project or the program has been completed or because the program or the project has been abandoned. So in that case, Your Honor, that part that had been saved under the law may be transferred to other items or may be used to augment other items of appropriations by certain well-defined officials of the government, namely the President, the Chief Justice, the Senate President, the Speaker of the House, and the heads of the various constitutional commissions.
You must be referring to Section 77 of 2024 General Appropriation Act.
I think so.
There are, you mentioned, two sources of savings. These are portions or balances of released appropriations that have not been obligated, free from encumbrance, arising from those two that you have just mentioned. You mentioned about completion or final continuance or abandonment of a program, activity, or project for which appropriation is released. You mentioned about efficiency. That's implementation of measures resulting in the improved systems and efficiencies. Now, what about unpaid compensation and other related costs due to vacant positions and leave of absences without pay? Can you not consider that as also a possible source of savings?
From a general or generic point of view, Your Honor, if those plantilla items have not been filled up, then in a general sense, this could be considered likewise as savings.
Does the law, I referred to Section 77 of 2024 GAA, make an exclusive enumeration regarding sources of savings? It may mention only two, but here you are espousing the theory that that may also be a possible source of savings.
Yes, Your Honor. I think, I'm not too sure though, but the word among others might have been used in Section 77.
I ask that because that is provided for in GAA 2014, Section 59. It is not mentioned in Section 77 of 2024 GAA. So that crops up the question whether it still forms part of the savings, but the law does not say only any of the. In any case, so may I now ask the petitioners in charge of special funds? I will back to it later on. in charge of, I understand that you divided the issues among the council. So, yeah, thank you.
With the permission of the Honorable Chief Justice.
Well, given this PowerPoint presentation, is it not possible that the source for and program appropriations may come from Y, which we term it as other portion? What do you think? Can that be the possible source of unprogrammed appropriations?
Your Honor, for me, what is clear is that per admission by the government, as labeled in the GAA, the one that was taken away, the 60 billion so far, came from sin taxes, Your Honor, because the GAA says this is the appropriation for sin taxes.
Yes, answer yes or no, or no.
No, Your Honor.
The reserve fund is isolated. It must remain untouched. That's why there is a barrier there.
Yes, Your Honor.
Which implies that reserve fund must be untouched.
Yes, Your Honor.
Isolated from the other portion.
Yes, Your
Now,
Honor.
the respondents, please, Solicitor General, is that the one that the government has been doing, that it may source such unprogrammed appropriations from the other portion?
Exactly, Your Honor.
Not from the reserve fund?
No, because precisely the DOF circular clearly stated that the GOCCs shall review and reduce to a reasonable level their reserve funds, taking into account their historical expenditures for the previous years. And the remainder, meaning outside the reduced or reasonably reduced reserve fund, will be the base for the computation of what should be remitted back to the Treasury. And in that particular example, Your Honor, your Y factor, which refers to the accumulated revenues over the past years, in the case of the PDIC, which is the other GOCC that remitted funds to the National Treasury, these are the unrestricted funds. These are the retained earnings of PDIC, precisely your Y factor. And that was the amount that was determined to be returned to the National Treasury.
Any refutation?
Yes, Your Honor. In the Bureau of Treasury's presentation for the House of Representatives on May 8, 2024, they determined the fund balance as from 2021 to 23 as premium for indirect contributors minus benefit claims. So that's for 2023, 38.8, and then for 22, 24, 2021, 27.1, for a total of 89.9 billion.
We have repeatedly mentioned fund balance. Where in that presentation is the source of the so-called fund balance?
Where in the presentation? That's actually my quandary, Your Honor, because they, based on the presentations, they just computed it based on their subsidy minus the benefit claims from indirect contributors. That's it. That's how they determine it.
Do you espouse the theory that it may come from the reserve fund?
Yes, Your Honor.
To refute what Solicitor General's just espoused?
Yes, Your Honor.
Thank you. Yeah, I will ask additional questions.
Thank you, Your Honors.
Thank you. Paragraph 3 of Section 11 of Republic Act 11223, Universal Health Care Act, says no portion of the reserve fund shall accrue to the national government, any of its agencies or instrumentalities, including government-owned or controlled corporation. How do you now reconcile this clear prohibition with the directive of the Department of Finance under the purported mandate of GA 2024 to remit the money to the National Treasury?
Your Honor, the prohibition refers to any part of the reserve fund or income thereof or therefrom from being remitted back to the general fund of the National Treasury. Precisely, this is what Special Provision 1D and DOF Circular 003 provided, which means that you make your own review of your reserve fund and the remainder, meaning outside of the reserve fund, is what will form the basis for the computation of any amount that is unrestricted and will be returned to the National Treasury. So very clearly, Your Honor, the reserve fund had already been set aside, and it's only the remainder from the computation of the unrestricted funds that may be the subject of a transfer or a return to the National Treasury. So there is no violation, Your Honor.
As early as in 1961, the Supreme Court, in the case of Henry Archbishop of Manila versus Social Security Commission, your number L-150045, promulgated on January 20, 1961, held that funds contributed to the Social Security, at that time, Commission, created by the Social Security law are not public funds, but funds belonging to the members or contributors held in trust by the government. Is that ruling of the court applicable to this case?
No, Your Honor, that is not applicable because the sources of funding for the Universal Health Care Act do not come solely from the contributions by way of premiums of the members of Philhealth. There are many other sources of funding for the Universal Health Care Act which do not come from, let's say, the paying members of Philhealth. That is only a part of the funding sources for the Universal Health Care Act.
Okay,
by and large, the majority is from taxes.
Let's delve into Article 6, Section 29, Paragraph 3. That's the Special Purpose Fund.
Yes.
That's the constitutional provisions which says all monies collected on a tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only. If the purpose for which such a special fund was created has been abandoned or fulfilled, the balance, if any, shall be transferred to the general funds of the government. Do you know of a decided case wherein the Supreme Court made mention of this special fund?
Your Honor, I do not recall right now the title of that case, but I know a legal basis for making a distinction between what is known as soft earmark and hard earmark. There is a provision, Your Honor, in the Administrative Code, the revised Administrative Code, that, if I may refer to my note, Your Honor.
Yes, please.
Executive Order number 292, Book 6, Chapter 5, Section 44, heading Accrual of Income to an Appropriated Surplus of the General Fund. And it says, Your Honor, unless otherwise specifically provided by law, all income accruing to the departments, offices, and agencies by virtue of the provisions of existing laws, orders, and regulations shall be deposited in the National Treasury or in the duly authorized depository of the government and shall accrue to the unappropriated surplus of the general fund of the government. In the following section, Your Honor, Section 45, the heading is Special, Fiduciary, and Trust Funds. And I quote, receipts shall be recorded as income of special, fiduciary, or trust funds, or funds other than the general fund, only when authorized by law, and following such rules and regulations as may be issued by a permanent committee consisting of the Secretary of Finance as chairman and the Secretary of the Budget and the Chairman, Commission on Audit, as members. So what I'm saying, Your Honor, essentially is if the law does not provide or create a special fund or a special trust fund, then any such income shall go to the general fund of the national government.
With all due respect, the Supreme Court in the case of Gaston versus Republic Planters Bank, jar number 77194, promulgated on March 15, 1988, the court had the occasion to enunciate a doctrine on this, and this is what the court said. Revenues that are levied for a special purpose shall be treated as special fund, which are administered for that purpose only. Once the purpose has been, for which the funds was created has been fulfilled or abandoned, the balance, if any, shall be transferred to the general funds of the government. My question is, one of the sources of funds to implement the universal health care system is the total increment of the sin tax collections. Can we not consider these funds that may be derived from the sin tax collections as funds considered held in trust by the Philhealth?
No, Your Honor. Let me refer to Section 37 of the Universal Health Care Act. Your Honor, if I may.
Yeah, please, proceed.
Referring to the very last paragraph, Your Honor, of Section 37 of the Universal Healthcare Act, may I quote, "The amount necessary to implement the provisions of this Act shall be included in the GAA and shall be appropriated under the DOH and national government subsidy to Philhealth. In addition, the DOH, in coordination with Philhealth, may request Congress to appropriate supplemental funding to meet targeted milestones of this Act." The implication, as far as I'm concerned, Your Honor, seems to be that all of the sources of funding, including those arising from the sin taxes, will have to go to the general fund and to be eventually appropriated by Congress under the DOH and national government subsidies to Philhealth, presumably taking into account the amounts collected from the various sources, such as the sin taxes. That is my understanding, Your Honor, but it is not the same as this law creating or providing for the creation of a special trust fund like the Coco Levy Trust Fund, which is set apart from the general fund of the National Treasury. Here, the law itself very clearly states that the amounts necessary to implement the provisions of this Act shall be included in the GAA, Your Honor.
My final question deals with Article 6, Section 25, Paragraph 1. Under this constitutional provision, Congress may not increase the appropriations recommended by the President as specified in the budget. Petitioners in GR number 275405 claim that there is an additional insertion of 449.5 billion to the unprogrammed appropriations, which originally was set at 281.9 billion. Clearly, there is a huge increase in that the total unprogrammed appropriations ballooned to 731.4 billion. The legislative intent of this prohibition, according to the Constitutional Commission, is to prevent enormous budgetary deficits. How does the bicameral conference committee account for such enormous increase? Is this not a clear contravention of this constitutional provision?
No, Your Honor, because that provision applies the prohibition to increase the budget submitted by the President does not refer to the NEP or the National Expenditure Program submitted by the President, but it refers to the budget of expenditure and financing, or BESF, which is the budget document specified in Section 22 of Article 7 on the Executive Department as the basis for the General Appropriations Act What I'm saying, Your Honor, is the purpose of that provision is, as you correctly stated, to prevent any budget deficit, any humongous or any very large budget deficit. That's why Congress has to look also at the funding or financing side, not only the expenditure side, like the NEP. Now, since the concept of unprogrammed appropriations is something like on standby, only when funds are available, only when there is an excess collection from revenue, only when new foreign loans are granted, then that is not counted for purposes of determining whether there might be a budget deficit, because it will only come to play when the corresponding funding would come in. That's why it's unprogrammed appropriations, Your Honor.
When the Constitution says appropriations, do that cover and program appropriations?
That is correct, Your Honor, but we have to understand the underlying reason for that particular provision. And as I explained earlier, we are referring to the BESF. The total amount of 5.7 trillion, Your Honor, was not changed in the GAA. It's still the same because we are only looking at the obligation side, referring to programmed appropriations and automatic appropriations. The inclusion of the unprogrammed appropriations is there only on standby, but it does not constitute the obligational the list of obligations that the government will have to comply as for its operations.
Attorney Colmenares, if you have any refutation, you expound that in your memorandum. My time is. I hope you're listening, since you are the one in your petition that made such allegation. You can expound your refutation as what the Solicitor General said. That concludes my interpretation. Thank you. Thank you, Chief.
Sige. Considering it's about 6 o'clock, we'll suspend the session again to resume on April 29. For the record, Attorney Maripe, we mentioned that Justice Amy Lazaro-Javier completed her interpellation. Same with Justice Antonio Co and Justice Japar Di Mampao. So session is adjourned. Thank you.